Hello, my name is Ian Larkins of Radius Law and welcome to our monthly commercial bulletin brought to you in association with LexisNexis. The recent case of Novaha Cooks and Viva Hunt Group involved a dispute about the requirements for bringing a claim under a warranty. The agreement stated that any claim under the warranties must be notified to the sellers within 20 business days after becoming aware of the matter. The difficulty here was whether the 20 business days ran from when the buyer became aware of the facts giving rise to the matter or from the date that the buyer became aware that there was a proper basis for advancing a claim. The Court of Appeal and Commercial Court agreed that the latter interpretation was the correct one, albeit for different reasons. The Court of Appeal stated that a purposive interpretation should be taken, and it was clear that the purpose of this clause was to stop the buyer from keeping a claim up its sleeve. Perhaps more interesting for lawyers reading the case are the arguments that were advanced concerning the proferentum principle, which provides that where there is doubt about the meaning of the contract, the words will be construed against the party who put them forward. The sellers argued that the principle now had limited effect. Acknowledging some of these arguments put forward by the sellers, the Court of Appeal agreed there was some court precedent to support this point, but Lord Justice Briggs noted that none of them concerned exclusion clauses, and more recent decisions concerning exclusion clauses continue to affirm the proferentum principle. The recent Court of Appeal case of One Step Support Limited versus Morris Garner and another of 2016 confirmed that the defendants were in breach of the restrictive covenants and that the proper method for awarding damages was the Rotham Park basis. See Rotham Park Estate Company Limited versus Parkside Homes of 1974, which states it is the price which the hypothetical willing parties would have agreed between them to buy out the restrictions. This approach was not limited to property cases as had been argued by the defendants. The case of Jazz Financial Products LLP Jazz versus ICAP PLC ICAP concerned whether a legally binding agreement had been formed by email exchanges and a meeting. In this case, there have been discussions concerning Jazz providing services to ICAP. There was a detailed email provided by Jazz setting out the proposal, and then a meeting in 2008 where the earlier email was discussed, and aside from a commencement date, no changes were made. Jazz sent a subsequent email stating that it was willing to sign whatever was necessary to record their agreement. Services commenced and Jazz invoiced ICAP, which paid, although ICAP claimed the second invoice had been paid in error. ICAP then disputed that a deal had been reached in the May 2008 meeting, as its representative did not have the authority to conclude the deal, that there was insufficient detail for it to be a binding agreement, and that it had been made clear that the deal was subject to legal advice. Ultimately, the case was decided in ICAP's favour, but this was simply because the court found ICAP's evidence and recollection of what had been agreed at the May 2008 meeting to be more reliable. It did not agree that the representative did not have the authority, and nor did the court agree that the agreement lacked sufficient detail to be a binding contract. There are a few changes under the Small Business, Enterprise and Employment Act that became effective in April 2016. And these are that the People with Significant Control register, the PSC register, means that companies and limited liability partnerships must maintain a PSC register and make it available for inspection. Full details of the PSCs will also need to be included on the annual confirmation statements submitted to Companies House on or after the 30th of June. Removal of directors. Any person that has not consented to act as a director but is listed as a director on Companies House Public Register will now be able to take advantage of a simplified procedure to have their name removed. Registered office disputes. The registrar will change the details of the company's registered office on the application of any person In April, the European Parliament adopted the General Data Protection Regulation, the GDPR, marking the final stage in the legislative process for the new Data Protection Regulation. The new law will be directly enforceable in 2 years' time, As previously reported, this brings significant changes to data protection law, including tougher fines up to the higher of 20 million euros or 4% of annual global turnover, breach notification requirements, a requirement for businesses to prove that they have adopted privacy by design approach, and more rights for individuals. Undoubtedly, some requirements will take time to implement, so businesses are urged to take action now to ensure they can meet the compliance requirements. Regretfully, even a Brexit vote will not allow many businesses to escape the new regulation, as it will be applicable to any business that handles EU citizens' data. The Information Commissioner's Office has published 12 top tips for businesses to prepare for the new law. As reported in previous months, the Safe Harbour scheme that allowed companies to transfer personal data to US Safe Harbour registered companies and comply with data protection law was invalidated in late 2015. Since then, there has been frantic work to create a replacement scheme known as the EU-US Privacy Shield. Regretfully, the EU-US Privacy Shield has not yet been implemented. The official working party, the Article 29 working party, has welcomed improvements that the new scheme is offering, but says it still has deficiencies. There is guidance available on the ICO website on what companies should do in this interim period, which may regretfully be a long-term period. The Competition and Markets Authority, the CMA, has again emphasised its concern about paid promotions not being sufficiently transparent and the publishing of fake reviews by issuing an open letter on the topic to those involved in marketing. The letter includes a stark warning that such activities can lead to civil and criminal enforcement. The letter also provides a link to its guidance. User-generated content. User-generated content, UGC, is content such as social media posts, tweets, photos and reviews created by private individuals and published on a website or other social media. This by itself is outside the remit of the Committee of Advertising Practice Code, the CAP code. However, the Advertising Standards Authority has now advised that if the content is adopted and incorporated by an organisation, e.g. by requesting content from users and then placing the same material in its social media, then it is likely to be caught by the CAP code. And accordingly, organisations will need to make sure that the content is responsible and not misleading, harmful or offensive. Comparative advertising. CAP has also published guidance for advertisers concerning verifiability for comparative advertising. To be verifiable, advertisers must set out the relevant information about a comparative claim in their ads or signpost how the information used to make that comparison can be checked. The Employment Appeal Tribunal, the EAT, case of Metroline West Limited versus Ajaj of 2015 has confirmed that employees that pull a sickie can be terminated for misconduct. Now, in this case, Metroline had doubts about Ajaj's claim that he was unable to work and arranged covert surveillance, which showed that he had exaggerated his injuries. Metroline then terminated his employment. The tribunal ruled that the dismissal was unfair as Metroline had failed to consider the specific duties that were required of him. The EAT, however, reversed this decision, stating that this was not a dismissal due to capability, but because of the misrepresentation that Ajaj had made to his employer. The recent case of Bartholomew's Agri-Food Limited versus Thornton of 2016 highlights the risks of drafting restrictive covenant clauses too widely. Now, in this case, the employer sought an injunction to prevent the employee from taking a new role at the expiry of his notice period. The restrictive covenant in his contract of employment sought to prevent him from engaging in work supplying services of a similar nature to customers of the employer for 6 months following termination. The court determined that the restrictive covenant was not enforceable, relying on the principle that a covenant which would have been unenforceable when it was first imposed will remain unenforceable. The contract dated back to 1997 when the employee joined as a trainee, and therefore at this time such a widely drafted restriction would have been unreasonable and unenforceable. The court stated that if the clause had been limited to customers that he dealt with prior to his termination, then it would have been enforceable. The employer's argument that it was reasonable to apply restrictive covenants in any event in this case, as unusually the employer was required to continue to pay him during the time that restrictions applied. The court, however, held that it would be contrary to public policy to allow employers to purchase a restraint of trade. The case of Private Medicine Intermediaries Limited versus Hodkinson gives a stark warning about the risk of not carefully managing sensitive employees. In this case, Hodkinson had a period of sick leave for work-related depression and anxiety following her complaint about bullying by her manager. PMI's chief executive wrote to her about the matter, and she replied stating that she was in no fit state to communicate without breaking down. The CEO wrote again, stating that he had spoken with her manager and that he wished to discuss with her 6 areas of concern. Hodkinson then resigned, claiming constructive dismissal and stating that the CEO's letter can only be intended by you to elicit my resignation. The Employment Tribunal found that Ms. Hodkinson was entitled to resign and claim constructive dismissal. Now, the test for constructive dismissal is that the employer has acted without reasonable and proper cause. The tribunal found that the 6 areas of concern referred to by the CEO were not serious matters and that most of them had already been dealt with. Accordingly, the company had acted without reasonable and proper cause. Now, this case does not mean that employers cannot contact employees on sick leave. Staying in contact is actually good practice, but it is important to consider the content of the correspondence, and in some cases, it will also be appropriate to consider the manner of the communication. The case of Wastany, the East London NHS Foundation Trust, has provided some useful guidance on how to navigate through the rights to manifest religious beliefs and religious discrimination. In this case, Ms. Wastany, who describes herself as a born-again Christian, is alleged to have made repeated attempts to convert a junior Muslim colleague to Christianity, including offering to pray for her and inviting her to church events. The NHS Trust disciplined Ms. Wastany, and she claimed religious discrimination and relied on Article 9 of the European Convention of Human Rights, which provides the right to freedom to manifest religious beliefs. The tribunal disagreed, stating that Ms. Wastany was not disciplined because of her religion, but because her actions blurred professional boundaries and placed an improper pressure on a junior employee. The Equality and Human Rights Commission has produced technical guidance which provides advice for organisations on the implications of age discrimination ban. It gives examples of how the ban works and explains who is protected and sets out what constitutes discrimination, harassment and victimisation on the grounds of age. BMW has successfully opposed the community trademark application for MINICARGO by a French company, LG Development, LG, for apparatus for locomotion by land, namely trailers, Class 12. BMW opposed the trademark application based on its earlier CTM for the word mark MINI for land vehicles, parts, components and accessories for all the aforesaid goods, also in Class 12. Relying on the argument that the MINICARGO registration is likely to cause confusion on the part of the public. BMW's opposition was rejected in the first instance, but was successful on its appeal to the Board of Appeal of the Office of Harmonisation of the Internal Market and at the subsequent appeal by LG to the General Court. Arguments were advanced about who would be the relevant public in this instance. The General Court confirmed that as it is a community trademark, the relevant territory is the European Union and not only France, as LG had claimed. Having established this point, the General Court considered the similarity of the goods and the marks and determined that there was a likelihood of confusion. Owners of European Union trademark EUTMs that have been filed before the 22nd of June 2012 need to ensure that any goods or services that are of interest to them are expressly protected. As you may be aware, trademarks are sorted into classes, and each class has a class heading, and under each class heading is a more detailed list of what is covered. Prior to the IP translator case, each EUTM was considered to cover all the goods or services in that class. The IP translator case ruled that the trademark must specify which of the goods or services in that class are intended to be covered by all trademark applications after the 22nd of June 2012, which was the date of the IP translator decision. However, Article 28 of the Community Trademark Regulation will now apply that rule retrospectively. Accordingly, EUTM owners who apply for their EUTMs before the 22nd of June 2012 should ensure that their EUTM is amended if it does not already expressly cover the goods or services that are of interest to them. This can be done by a relatively straightforward process, but this must be done before the 23rd of September 2016. The Competition and Markets Authority has issued new guidance to assist businesses that are still grappling with the requirements of the Consumer Rights Act, particularly the requirements that contract terms and notices used by businesses in transactions with consumers must be fair. The guidance, which is available on the gov.uk website, takes the form of a series of short illustrated fact sheets. Thank you for joining us for this month's Commercial Bulletin. Please feel free to contact me if you would like more information on any of the topics covered, and if you have not already done so, you can get access to more content with Lexis PSL. Any other feedback of our bulletins is of course also welcome. We'll be back next month with another update. Until then, thank you and goodbye.